The Georgia teenager accused of killing her mom and stepdad has a new lawyer, and he came out swinging at a hearing today, alleging there's a lot more to the story of Sarah Grace Patrick than authorities have released to the public.
Now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning.
With the teenager in the courtroom today, the defense unveiled what they say is newly discovered information. Information they say points to potential new suspects that it says could change the trajectory of this case. We're on the case, presented by Law&Crime. I'm Stewart. Sarah Grace Patrick has been in jail for roughly 1 year. She was arrested and charged with the murders of her mom and stepdad in July of 2025. Today, Patrick was in the courtroom once again in Carrollton, Georgia, roughly an hour outside Atlanta. We did see her flash a smile as she talked to her new defense attorney, and that attorney's name is Sean Hoover. He replaces LaToya Williams. She's no longer with the Georgia Public Defender's Office and is no longer defending Sarah Grace Patrick. Now, Hoover claims there is new information that just came in.
That now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now.
So as of right now, the trial is slated to begin on August 3rd. But after today, all of that could change. And up until this point, we really haven't learned a lot about what type of defense Sarah Grace Patrick may have to the allegations that she killed her mom and stepdad. And before we get into what was some new bombshell information that appears to have come out today, I want to break down how we got to this point.
Can you respond? Off of Willie Walker Road, reference to a cardiac arrest.
February 20th, 2025. A call comes in to 911 dispatchers. It's a call for cardiac arrest.
Reference to a cardiac arrest. Complaints advising that the mother and the stepfather are called to the touch. They think they're beyond CPR and doesn't see anything around them that's suspicious. Law enforcement is en route with you.
We have not heard the 911 call that was made from the home of James and Kristen Brock, but we do know the caller was 17-year-old Sarah Grace Patrick. She allegedly told police that it was her 6-year-old sister who found their parents shot dead in their bedroom. The dispatcher says that the caller, Sarah Grace Patrick, stated that the Brocks were cold to the touch and that she did not see anything suspicious around them. Now, we've covered this case extensively since Sarah Grace Patrick's arrest last year. So to see our previous coverage and our interviews with some of the important people in this story, you can go to the Sarah Grace Patrick case file, which is on the Law&Crime Plus app. So let's go back to that day, February 20th. You have deputies from the Carroll County Sheriff's Office. They arrive and they discover the Brocks shot in their bed. Deputies say that they conducted a relentless investigation that went on for months. And as that investigation was ongoing, Sarah Grace Patrick was very active on social media, talking about grief in posts on TikTok like this. She also spoke at her parents' memorial service at their church.
I just wanted to say goodbye to my mama and Jamie since we never got the chance to.
Now, that's a speech that has been a point of debate for investigators and the Patrick family, those who have stood by Sarah Grace's side.
And never take a hug or anyone or anything for granted, and love with all that you have in you like they did. And lastly, my take on not taking people for granted. I want to thank my family, also known as my Cata fam, my grandparents, my siblings for helping me get through my worst nightmare. And last but not least, I want to thank Tasha, Bree, Nate, Lane, Kimberly Hayes, Kim Bowling, Katie, and most of all, my father, Angie, and Ben for making such a big difference. Jamie and Mama would have thanked y'all too. I love you guys, and so do they. I'm sorry.
Now, you heard in that speech, Sarah Grace Patrick, she lists a group of people to thank. And then at the end, she says, sorry. Investigators called that sorry a red flag. They believe that she was just acting. Now, there were no arrests in this case for months until last July when Carroll County authorities called a news conference.
Today, we can confirm that an arrest has been made in the case. Kristen Brock's 17-year-old daughter, Sarah Grace Patrick, has been taken into custody and charged with 2 counts of murder and 2 counts of aggravated assault.
Law enforcement said there was a, quote, mountain of evidence that proves Sarah Grace Patrick killed her mom and stepdad. But still to this day, we don't really know what that mountain is made of.
If they say they have a mountain of evidence, that folder was pretty thin.
That is Sarah Grace Patrick's biological dad. His name's DJ, and he spoke with us in one of his first interviews last July. He believes that his daughter is innocent, 100% innocent, he said. In fact, he was with her in the interrogation room right before a warrant was put out for her arrest. He then drove her to the sheriff's office to turn herself in, and they were told that Sarah Grace Patrick was going to be charged with the murders of the Brocks. Now, also on Sarah's side is her grandfather, a man named Dennis Nolan. He is Kristen Brock's dad. So he lost his daughter in this case.
I mean, let's face it took them 4 months to arrest her. You know, the time lag. If they had anything of substance that came about from the initial investigation, they would have arrested her immediately.
But it's important to note the family dynamic here. Not all family members are on Sarah's side. I spoke with Kristen Dowda. Her mom is James Brock's sister, so he was her uncle. And Kristen has gone public saying that her uncle felt very differently about Sarah Grace Patrick.
He said repeatedly that she's not the Sarah that you guys know. You don't see the real Sarah.
Now, here is Kristen's mom, Kimberly Bowling. She took the stand during a bond hearing last August.
The defendant is charged with the brutal murders of my brother, Jamie, and my sister-in-law while they were lying in their bed. Shot multiple times, including both shot in the head.
Now, that was emotional testimony, and when you hear that testimony, and you hear that the Brocks were both shot in the head, it does make you wonder about the 911 call that Sarah Grace Patrick made to authorities when dispatchers say the caller found the Brocks to be cold to the touch and not needing CPR, and that there were no signs of foul play, at least from what the caller could see. Now, it's important to note, we have not seen crime scene pictures. We have not seen body cam video from the scene. At that August hearing, the judge denied bond for Sarah Grace Patrick, and she has continued to be held in county jail. Hours after that hearing, a grand jury indicted her in this case. She is now charged with 2 counts of murder and 2 counts of aggravated assault. Initially, the judge set a trial date for January of 2026, but then that got moved to August 3rd. Both the prosecution and defense did appear ready for that date, but then came some big bombshells that appeared to be dropped today in this court hearing, with Sarah Grace Patrick's new attorney now asking for a continuance.
What I thought was just a chain of custody issue turned out to be a much larger issue dealing with GBI, the sheriff's office, police department, and just evidence in general.
Sarah Grace Patrick's defense listed several reasons as to why her trial should be delayed once again. One of them being that they just need more time because they have an entirely new team on Patrick's case. But Hoover, the attorney, also says that there's new evidence that's been uncovered just in the last week. He says it has to do with an officer who responded to the scene on that day in February 2025.
But on Friday, when I met with the state to go over the physical evidence, they sent a supplemental report from an officer with local law enforcement. The issue is this officer is in other reports, this officer is on the witness list, but from the information we received, the information Ms. Williams had, this officer literally didn't really do anything in the reports. He was just there. Now we find out that this officer did not write a report. However, he went to the DA's office literally last week and said, you know what? Well, and I'm sure they can correct me if I'm wrong, my understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person we never knew the name of from the discovery sent over by the DA. And that officer's hunch turned into, it went to another person that had the gun, and the officer tested the gun and then gave it back to the other person. We had no idea these two people existed. We had no idea this test existed. We had no idea there was a possible another gun. We had no idea there was a possible hunch. We have no idea how the officer came to that conclusion.
It's important to note that this is the first time that we've really heard anything about an alleged murder weapon in this case. When we have asked law enforcement about whether they have the murder weapon, they wouldn't answer that question. And now you have the defense today saying that there was a gun, part of the investigation. They say one that was potentially used in the shooting that an officer thought may have been pawned, and that there are other people who potentially came in contact with that weapon that Patrick's previous defense team didn't know anything about. The defense is also alleging that prosecutors were unaware of this as well.
We are now in a position to where I honestly don't know, was this one rogue officer that just did literally whatever he wanted to and never reported to anyone else? Or is there more involved in this? I need to now follow up on the hunches. I need to now follow up on how he even got to this conclusion. I need to now follow up on the two people, well, it is more than two people at this point that I didn't know about until Friday, literally Friday afternoon, that I need to now find them, follow up on them. I need to go to the pawn shop to see what happened there. I mean, there's so much more information that we have uncovered since I've taken over the case and I brought my team on, that we can't fully be prepared to go forward with defending Ms. Patrick. As of right now, and again, this is not the DA's office that held any of this information. This was now I see there's a problem. I thought it was a small problem. It has snowballed into a huge problem, and as of Friday, now we know that there are officers that really didn't do anything or didn't provide anything in evidence that was presented to or turned over to Ms. Williams and then turned over to me, that now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now. And again, the case law, the court's already the case law, so I'm not going to delve into that, but we are in the position now that I understand this trial was set, or this case was set to go to trial. And I understand that Ms. Patrick has been in jail this entire time. She and I have had this difficult conversation, but I'm in the position, due to her age, due to the circumstances surrounding the case, and due to the mitigation aspect, the new information aspect, the possible other weapons, other people. I mean, there's so much that has been uncovered within the last few months that we have delved into this case that we're asking for more time so we can be prepared. And not only for sentencing, but for the case in chief itself. The mitigation aspect of what we are looking into not only goes to sentencing, again, it goes to actual issues with investigations that these officers conducted, especially the lead investigator in this case. So the mitigation issue deals with her age, sentencing, and the case in chief, but now we know GBI evidence that there's still more coming in, still more information coming in.
Now, it seems the defense wants to take a more aggressive approach when it comes to digging into the investigation and how they reached the conclusion, law enforcement, that Sarah Grace Patrick is a killer.
Now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning, but apparently a couple years later, a couple weeks before trial, he remembered, now I need to write a report, and there's a new gun we need to talk about, there's new, again, forensic evidence we need to talk about, there's new contact information we need to talk about, and this is not from the state, this is information that we uncovered because I saw there was a problem, and the problem turned out to be a lot larger than what it was. With all of that said, Your Honor, due to the nature of the crime, due to the fact that Ms. Patrick is potentially looking at, 2 life sentences without possibility of parole, as a defense attorney, I need more time to uncover or to just delve deeper into all of this new information that we've uncovered before I can properly say that I can represent her zealously and cover all my bases. This is an issue that I don't want to come back 20, 30 years from now and have to relitigate all of this, because another officer popped up with new information that we didn't know about before. Like, this is not I'm grasping at straws. This is there's an actual issue here that the state and I need to uncover before we can properly move forward with this case. So for those reasons, Your Honor, unless the court has any questions, we are asking for a continuance so that my team that we put together that is suitable to handle all this information can actually do just that. We just need more time because there hasn't been enough time yet.
So you have the defense laying out several reasons as to why they believe that this trial should be postponed once again. But then prosecutors responded, and they started by pointing out that Patrick's new defense attorney actually came on in February.
First, in basically the order that defense counsel went through them, he said that there is a new team that they put together specifically for the mitigation or issue, specifically regarding the DFACS documentation. I'll break that down a little bit. First, they put their new team together and they want to change their expert, but they're only doing this in June. February, they didn't ask for this. March, they didn't ask for this. April, they didn't ask for this. May, they didn't ask for this. And well into June, they didn't ask for this. Here we are on the eve of trial, and they're now asking to change their expert. If they wanted to do so, they could have done so then. Prior counsel on the case, Ms. Williams, when she got the case, she hired Dr. Schaefer very quickly after getting the case, and they still didn't get a report for 6 months. Not through defense counsel's lack of effort in getting that, it was just Dr. Schaefer didn't turn it over. I can understand why they want to change their expert. If they want to do so, they've had 6 months to do it. They still have, from my count, 21 days. We are 3 weeks from jury selection. We're still well within the 10-day limit for the state. They can go ahead and do that sort of thing. As far as the DFACS records that we brought up, we got those DFACS records a handful of weeks ago. They are largely duplicates of what was already turned over. The significant portion of those documents relating to the defendant and her history were already turned over, already examined by Dr. Schaefer, already examined by the state's expert that we hired back in February for this. That is something that they could have done. They simply chose not to.
The defense had also brought up concerns about sentencing issues for Patrick having not been addressed related to her age. She was 16 at the time of her parents' deaths.
If that is genuinely an issue for sentencing, a verdict favorable to the state being reached, potentially sometime in August or September or later, should it be required, the court can always set aside sentencing farther down the line so that the defense would be able to investigate these sentencing issues. There are other alternatives other than pausing the trial.
Here's what the prosecutor said about the concerns from the defense on evidence in this case. This is what he says about a gun that was potentially tested in the case, and he says reportedly it was not the murder weapon.
Second, as far as the outstanding evidence from the GBI, that was basically a request for, I'm going to use a term of art here, bench notes. It's testing procedures, documentation that the testers make during their process. The defense did not ask for that in February, or March, or April, or May. They asked midway through June. Those things are now being worked on, but we had 6 months to get those documents into their hands, and they didn't ask. Now the state is going to help facilitate to get those documents into their hands. I'd like to see them as well. They're not necessary for the state's case, but I would like to see them as well. We're working on getting that for them. As far as the outstanding evidence regarding that supplemental that was turned over on Friday, we don't have a rogue officer here. I do appreciate the hyperbole of defense counsel, but we do not have a rogue officer running wild. We had an officer who tested a firearm in relation to this case, or any case, to be honest. It was not the firearm used in this case. They tested it, they ran it through NIBIN, they did all of the proper testing procedures for that firearm. It's not related to this case. Multiple firearms were tested in relation to this case. None of them are the firearm in question. This is just one of those that the defense was not aware of prior to Friday. It's the exact same thing as all the other firearms we have. There's going to be potentially 2 new leads to chase down. But those things are law enforcement officers. They're going to be here. They may be brought up by the state for cross-examination. If not, the defense can put them up under their own subpoena power in their case in chief. There's nothing to that would require any additional time. again, the rule here is the 10-day requirement. We are 21 days out as of right now when I stand here in front of the court. We think that there is no necessary foundation legally for the state to continue this case. We think factually there is no requirement that the court continue this case. And we think that overall the needs of justice do not demand a continuance in this case. Instead, they demand that this case be reached for trial on August 3rd as set.
Yeah, just out of an abundance of caution, while I know the rule, some may not. You mentioned 10 days.
Sure.
And that we're 21 days out. I know what that means.
Yep.
Can you explain that?
I can. So the rules for discovery in Georgia require that all of the information from the state be turned over to defense counsel 10 days prior to trial. For us, we are 21 days out as of today. That counts business days and weekends. So we do have a significant amount of time to give things to them. There may be more things coming, and I can illustrate this with something that was mentioned up in opposing counsel's brief. They were just in receipt of the defendant's calls while she has been in custody. I'm going to turn those over at 10-day. Again, anything from July 1st through whatever that 10-day is. But I cannot turn over things until I have them. So they're not going to get those until 10-day. As much as I would like to give them the calls that she is making next week, I can't turn over documentation that we don't have.
Then the defense got the opportunity to speak once again, and they countered the prosecutor's claim that the gun tested was not the one used in the murders.
That's the problem. We are literally getting evidence now that we did not have before. Now, what the state said was, well, this is a gun. It went through the same test that all the other guns did, and it wasn't one of them. I don't know that, because just because the officer that didn't write a report for like the last 3 years is now saying that I'm supposed to just take the state's word for it. As a defense attorney, I have to investigate this. At the point where the state makes this bold assertion that, well, this is a gun that we tested like all the other guns and it doesn't exist, we gave it back, I have to do more. I have to see those tests. I have to first, before the test, I have to figure out how he came up with this quote-unquote hunch. I mean, we're in a murder trial, a double homicide, and now rogue officers are bringing in evidence that no one knew before and saying, well, I got it off of a hunch. The state didn't bring that up. The state wants to say that this is just another gun that didn't test as the fire weapon, or the actual weapon as arrest. I can't go with that. The court can't go with that, and a jury can't go with that. As a defense attorney, I have to first start with, what were you doing to where you didn't write the report at the beginning?
This is what the judge said about making a decision on pushing the trial out even further.
My intention is to have an order to y'all. I'm going to say no later than midday Wednesday, but I really want to have that order out by tomorrow afternoon. So give me till midday Wednesday just in case something happens, but I really am shooting for tomorrow afternoon to have that order prepared.
So potentially Tuesday or Wednesday this week, this judge will decide whether this case will be delayed once again, or if Sarah Grace Patrick will stand trial for the murders of her mom and stepdad next month. That will do it for On the Case, presented by Law and Crime. You can subscribe to us on YouTube and Spotify, and we are also now streaming on Peacock. I'm Chris Stewart. We'll see you next time.